Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamlin and Kerrigan. I've been practicing law in New Hampshire for approximately 39 years and in the Commonwealth of Massachusetts for approximately 28 years. I'm going to be talking today about renting your home. You might be in a situation where you're relocating temporarily. Maybe you're going to California for your job and you're supposed to be there for a year or two. And during that period of time, you don't want your property idle and not making income, so you're thinking about renting it. You could be in a situation where you have a mother-in-law apartment, in-law apartment, and you're thinking that you don't need it now for the in-law that you were thinking about, or maybe you never did use it for that. And it's a separate intact unit, and you want to think about renting that out, or maybe you're renting a room in your property. I'm going to talk about all of those situations as some practical and legal issues that you should be dealing with when you're considering renting your home. First is to decide what you're renting. If you're renting a um, room in your property, one of the things that you don't want to do is you don't want to enter into a lease itself. If you enter into a formal lease situation, that might expand it into a true landlord-tenant relationship. You do have a tenant relationship, and that tenant does have some rights. But in New Hampshire, you have a specific statute, a shared facility provision that if that person is sharing your living area or your kitchen, they have less rights, and it's easier to get them out of the property under those circumstances. And there's a specific statute if you are thinking about renting your a room in there that's going to be sharing a common area of yours, so you're living there and you're sharing with this roommate. Think about that. Don't think, be careful about just getting an online lease because it really doesn't fit. You want to get that person out if things aren't working. It's a lot easier to get them out if they're a shared facility rather than when you sign a lease, then you have a different situation. If you have an in-law apartment, maybe the apartment above the garage or over to the side of the property, it's got its own kitchen and bathroom and everything else, so it's not sharing your facilities like that other than the driveway. In that situation, you do have a lease and you want to think about a full-time lease. If you're renting your house, you want to do a full-time lease. One thing that you want, and somebody like myself can help you out in regards to that, you want to think about things like, are you going to allow pets? If there's going to be a portion of the property they can't use because you're locking up that portion, what are you going to do with that? Are you going to lock into the garage or something your possessions? Are you going to allow them to use your furniture? Is it going to be furnished property? All of those things you want to think through, and you want to deal with those issues. You want to think about, are you renting them for a year? If you're going to be renting for a year, and you're coming back, you want to find out, you want to make sure you have a good comfort level that they are going to be out within their time period. If they don't, you might still want to do, just in case, what's called an eviction notice. And you can tell them ahead of time you're doing it within 30 days before they leave, just so you're primed that if they don't leave, you can go into what's called a landlord-tenant writ into the court system and do an eviction. You're not saying they're going to do anything wrong. That eviction notice isn't going out to anybody else. They're not being sued at that point, but it's a prerequisite. So if you're saying that their lease is ending and you want to take the property back over, again, that's good cause for you to moving back in. That's a good reason for you to do that. In that situation, you're doing the eviction notice form online. Somebody like myself could help you out with that if you need to, but you want to do that just beforehand and explain to the tenant that circumstance. So you're really just making sure that you can move back in as quick as possible when your issue going on in California, your business job is ending or whatever else may be. Maybe you're a snowbird and you're just renting the property for a few months, and this is the first time you've done a snowbird, so you have your property in Florida or the Carolinas, and then you're coming back up here and you want to make sure you have the property back when you move up here. So in those situations, you definitely want to think about making sure they're going to leave. And if you have any inclination and they're not going to leave, give them the eviction notice, politely tell them why you're doing that, and then you're ready, you're time to go to court with a lawyer if you need to. If you do a landlord tenant, I've done another vlog, don't check off the box if they owe rent, just go straight for the eviction. So the box on the first page of the landlord tenant writ that you can check off for up to $1,500, don't do it. You don't want any of those claims. You want to just have a straight eviction. Important issue when you're dealing with renting your property is, including renting a room, but particularly if you're renting a standalone property and standalone in-law apartment, or you're renting the entire house, go to your insurance company and make sure you get the right insurance for that. The idea of saving on the premiums, not letting them know that your homeowner is no longer occupying property, is a very bad mistake. For one, it's dishonest, and that's important too. But it's also, you're paying a premium for real issues. The boiler catches on fire and burns a portion of the house. Maybe the tenant has an electric vehicle and the battery catches on fire in the garage and burns the portion. Lightning hits. There might be a slip and fall by the tenant. The tenant might slip and fall and say that you're responsible for taking care of the ice treatment of the driveway. Any of those, or somebody else. Any of those situations, the insurance company is going to look carefully at the circumstances. If they find out that you're not paying the premium for a rental, but you're paying a premium for a homeowner, which is lower generally, because as a homeowner, you're on site and you're paying attention to those things, then you're not getting insurance. Why pay a premium when you're not going to get insurance? It's a bad business decision. You're not just saving money because you're doing insurance for those big issues. So make sure you protect yourself in regards to that. I'm Attorney Dan Marr. I've been doing this for decades, and I'm happy to help with you at 603-883-5501, 603-883-5501, or you can check out our website, nationallaw.com, check out my bio, and you can look at my weekly vlogs in regards to a variety of topics, all identified by title. Thank you. Look forward to working with you. Opportunity arises.